SJC-13536 in the matter of an impounded case.
Okay, Attorney O'Connor.
Thank you. Good morning, and may it please the court, Ann O'Connor on behalf of the petitioners. The question before this court is whether the single justice abused his discretion in declining to direct the first justice of the Boston Juvenile Court, or BJC, to either vacate the court's policy for scheduling non-emergency motions or clarify an apparent misunderstanding about the court's requirements for obtaining a motion hearing. In his decision, the single justice accepted that the BJC's policy requires counsel for a child or a parent who wishes to be heard on motion, a non-emergency motion, to obtain agreement from all other counsel on the case to at least 5 possible motion hearing dates before filing the motion, which they do via an advancement form. But it emerged in the filings before him that, as the single justice repeats at, the first justice, pages 8 and 10 of her brief, the court routinely acts upon advancement forms that contain fewer dates. And the court's data show that the court will advance cases where there are actually no agreed to hearing dates on an advancement form. Two BJC employees stated in affidavits that the 5 agreed upon date requirement, what counsel who practice in the court believe is a requirement, is in fact simply a recommendation. And the BJC's data also shows that a party is going to be heard more quickly if their lawyer gives no agreed upon, most quickly if the lawyer gives no agreed upon dates on the advancement sheet, a little less quickly if the lawyer gives between 0 and 4 dates, and if the lawyer adheres to what they reasonably believe is a 5-day, 5 agreed upon date requirement, it's going to take the longest for those people to be heard.
Counsel, could I just interrupt you for a minute? And I understand that in your papers you included some extreme examples of really long waits, but if memory serves, isn't the record here that the average is somewhere between 13 and 20 something days?
Yes, Your Honor. Unfortunately, and I regrettably didn't appreciate this until I was preparing for today, the data that we have from the BJC, it doesn't really help us because it's not just, I took it to be all the motions filed in C&Ps for this 55-week period, or care and protection cases, I apologize. In fact, in preparing and rereading the affidavit from the Judicial Secretary who put the data together, it's all motions filed in the BJC over those 55 months. It's motions filed in C&Ps, motions filed in children requiring assistance cases, and motions filed in delinquency cases. And there's no delineation of, so we don't know how long parents and children in care and protection cases wait on average because we just have the numbers for the 3 different kinds of cases.
Right. Well,
so,
it would seem to be a problem for you if that's the case with what we have, right? Because what we have seems to suggest you've got a juvenile court department division that's incredibly busy, that does incredibly important and serious work, some of the most serious work that we do in the Commonwealth, which you're a part of that ecosystem. So the procedural due process claims that you're talking about are really, really important. I'm just struggling to find in the grander context of those kinds of waits that the court trying to get the parties to get dates that work for everybody, so we don't have further delays with just picking these arbitrary dates from the clerk's office, that now we get all of these motions from everybody saying, oh, that date doesn't work for me. I'm struggling to see where the single justice abused his discretion in this case, because I just don't see where the answer is to this.
I think the most clear answer is in declining to require the first justice to let everyone know that you can give fewer than 5 agreed upon dates. Because the only place that appears is in impounded materials. So the practitioners, you know, and you have affidavits from 8 practitioners who have practiced in the BJC between, I believe it's 6 and 28 years roughly, who all believe that 5 days are required and who all say requiring 5 days, particularly post-pandemic. I mean, this practice has existed for a very long time. In fact, the clerk magistrate says it's the most efficient way to do it, but it's the only way the court's ever done it in the entire time she's been there. So the practice has existed for a very long time. The practice became untenable after COVID because lawyers are no longer there together every day. Can you do this date? Can you do that date? You know, when we're all together.
I guess I don't really understand that. Why can't you just shoot an email to opposing counsel or a text?
That's what they do, Your Honor, and what they found is there's a difference, right? And I think, you know, human nature, if you and I talking
Right,
in the
there is a
room,
difference, right, yeah, and I understand the example that you're about to give, but it's a constitutional difference? You're suggesting there's been a due process violation. So
because
explain that, why the rapidity of finding a mutually convenient date via text creates a due process problem that it doesn't create when it's live.
I believe the experience and certainly the affidavits show that what the lawyers who do this every day and have done this every day for years and years are experiencing is that while it used to be easy to get a date from a colleague you saw every day, you're all in next Thursday, maybe you have 3 cases on, what's taking on 1 more, versus when I'm emailing that colleague who doesn't have to come to court very often anymore, and when they're there, they're usually in and out. Maybe now they're giving me the dates that are convenient for them as opposed to the dates they can do, and that's resulting in putting dates out. And I think one of the examples is in the Mizell case where she wanted a July date after conferring with all counsel, and that, you know, that takes a while. The soonest date she could get was 2 months out. And my sister says, well, there's no due process problem because she got the date she asked for. Well, that's not the date the human being who was without her children for all these months wanted.
It's not, but I'm with Justice Wendland on this constitutional infirmity, because what you just described to me seems to be more of an ethical issue than a constitutional issue. Because if lawyers are picking dates that are convenient for their schedule versus their clients, how is that a constitutional issue, and how is that the first justice's problem?
I think, and I know I said at the beginning that the data is not helpful in determining how long it takes in a C&P case. I do maintain that, but the data does show that regardless of what kind of case it is, the fewer dates you give, the quicker date you get. So I think that's what the problem is. So requiring the 5 dates, and again, if it's not required, then if the single justice would let folks know that, or pardon me, the first justice, then there'd be less of a problem. But to date, it's only existed in impounded documents. I suppose now that we're here, the word may get out, and that maybe is going to help. But to this point, it's not been something that the first justice has been willing to tell, the whole
When you say
bar.
hasn't been willing to tell, have you had a meeting with her? Have you tried to discuss this and that?
We had one meeting in October that was unhelpful, unavailing. We met again, I asked to meet again in November. The first justice declined, and then I asked to resolve this matter for the first justice just to make that announcement on her own, and she also declined, through counsel.
Counsel, may I ask one quick question? This is a standing order, right?
No, Your Honor.
This is just the kind of, this is what we do here in.
It's an unwritten, yes.
Okay.
So, and I see my time is winding down, so unless there are other questions, thank you.
Thank you. Okay, Attorney Green.
Good morning, Your Honors. Assistant Attorney General Julie Green for the First Justice of the Boston Juvenile Court. There is no basis in the law or the facts and evidence to vacate the BJC's longstanding policy procedure for scheduling motions and motion hearings in non-emergency cases. The procedure is well within the discretion that is expressly conferred by Juvenile Court Rule 7D. And the extensive data that the BJC has assembled and presented to the court shows that it is not causing pervasive delay, as the petitioners
Don't we need to see
suspected.
the information on the care and protection cases separate and apart from the other ones, though, to know that?
It's true. All of the data for all of the motions and all the different types of proceedings is together in the 353 that we presented.
So how do we know whether what you're saying is true, that there's no delay overall?
Well, we know what the average numbers are, and we can see what the types, how quickly hearings in general get heard. I'm sorry, I can't tease those apart for you. But I would say that, you know,
Are you
they
saying
all
it can't
concern
be
child
done?
welfare.
I'm sorry, you're saying it can't be done, or you don't have that with you?
On this record, I can't tease it apart for you. It certainly could be done. What the data does show, though, is that at least across all motion hearings, and there's no reason to believe that care and protection proceedings would be any different from other types of extremely important child welfare proceedings heard in the juvenile court, that there is no pervasive delay, and that the two examples that petitioners presented in their papers were extremely regrettable and should not have happened that way. But the data show that they were anomalies. And so I think this court need have no fear that that type of, unfortunate sort of human error is happening regularly in the
Attorney
BJC.
O'Connor mentioned that there was a meeting. Were you part of that? Is there?
I was. It was a settlement meeting. The effort was really to determine whether is there a better way that this could be done. And I'd just like to point out that really conspicuously absent in the petitioner's papers is any sort of suggestion, well, why don't you do it this way? I think the reason, the principal problem that I think the petitioners are pointing to is the delay involved in conferring with other counsel at the sort of step zero of the process. And to that I'd say that need for conferring serves an extremely important governmental interest, which is the court's
Excuse me, I thought
concern.
opposing counsel was saying that it's the need to confer on 5 dates, that finding 5 mutually agreeable dates is really difficult. And so a lesser number strategically, if you are in the know, is better for your client. Why not just tell people that?
That is absolutely what people. Let me start this again. The court does communicate routinely with the bar. There are regular bench bar conferences. This is certainly something that could be discussed at a conference. There's no effort to hide this. The information about what's required to obtain a motion hearing can also be, one can go to the clerk's office and ask how to do it.
It seems like the rule followers are being penalized.
You know, I think there's a sort of a false premise here. We are not sure where the perception originated that the number is 5, whether it's a requirement or a
Since it's not
recommendation.
written, I guess that'd be the issue, right?
Sure, I appreciate that the procedure isn't written down. That's the common practice across all of the juvenile court divisions. Practitioners are aware, and they're aware that if they want to know, they need to ask questions.
I cut you off, so please tell me what you were going to say.
So the first justice, I think, has never said that 5 is required, or we're not exactly sure where that perception originated.
Is it? Are there
but-
5 blanks on the form?
No,
Oh,
there are
okay.
not 5 blanks on the form. We sort of anecdotally, not in this record, we suspect that it was actually something said by an attorney to other attorneys. But in any event, what I'd like to stress is that I think the data shows that there's no widespread misunderstanding in the bar. What we see in the 353 motions is that 216 of them requested less than 5 dates. So to the extent that there is some confusion among some segment of the bar, absolutely, I think that it would behoove the court and the petitioners to raise the issue at one of the public bench bar meetings, which are held at least quarterly. If there are no further questions, I will rest on my brief.